Okay, I am live now. I was having some internet connection problems. So let's see one moment here. I want to get into the JC hearing. Let me find the link. I was cleaning I was cleaning in my office and I disconnected by accident all of my Wi-Fi, which, yeah, was really dumb. But let's see if I can get into this hearing. Sign in to join. I forgot you needed to do that. So sorry, folks. We will get started here in a minute. I am signing in. Wrong password. Well, shit. Let me try another way to sign in. Let me go back. This sucks. I remember I had this problem last time. They should not require you to have a Zoom account. Skip for now and sign in. Okay. I want to turn my audio off and let's join. Okay, we should be good now. Let me see if I can share my screen. And I can. And that is the JC hearing. I don't know if we have any sound yet. I want to.
Sorry, everyone. Can you guys hear me?
We can hear you.
Okay. I apologize. That was my bad. I got to the same screen like 4 times.
I think Stratton said he can't make the meeting.
Okay, see, my mic was off there. I was cleaning like a dervish.
Oh, no.
Get
No, that
in
was the last
chat so
meeting.
I can
I don't know
see
about
your
this one.
comments. I'd really appreciate it. I hate this continuity.
Are you saying Montoni's not coming?
I don't know.
Oh, you don't know. All right, I'm going to call him.
We do. I don't think I put any Grand Marnier in this, though. If we have a break, we'll take care of that. So come on in to chat. Somebody let me know if LP
We have like
Allies is streaming
5
as
kids
well.
over here right now, so if there's some screaming in the background, it's fun mostly. So
Hey, Nathan.
Yeah. Just please mute yourself when you're not speaking to solve that problem.
So just as a guest at a county affiliate meeting yesterday where the petitioner, in this case, Jesse, was chair pro tem and had pretty much stated he doesn't know much about bylaws or Roberts, which I think shows in his AI-generated petition. That's no disparagement upon him as an attorney. Being an attorney is an
Mike
entirely
Seebeck,
different animal.
are you the guy that wears the tie-dye ties to the convention?
Among other things.
Yeah. Sick. I love it.
Thank you.
No, it's not going to be over today. They have to then think about it. We have a national convention coming up, so hope everything's going to be over by then, I suppose. I don't know. I think they're waiting for one more JC member. Remember, you can go to Lpedia and read the filings. As I said, Mr. Campbell's was quite obviously written by AI. So that's not a reflection upon his abilities, but it is upon the fact that he just used AI, and it is so bad. It is so bad. The JC needs to be like
checking audio test
and require certification that you did not use AI, and if you did, to identify what portions that you used it on. If we all just want to do argument by AI, none of us are necessary. The JC's not necessary. The petitioner, the respondent, just have AI write all of the stuff, hear all the stuff, and none of us are necessary. It's so disrespectful in my point of view.
All right, I've called and texted Mark, left messages. He'll either come or he won't.
I'm gonna
But
try to
I
get a
guess
hold
we can
of.
begin.
Stand by one moment.
Recording in progress.
Okay.
Okay. So the agenda is the same as last time. Opening statements by the appellant and then the respondent. The appellant can reserve time, 10 minutes each. Then I've done a random selection. The order, the random order I came up with here is Krawchuk, Seebeck.
Nathan, this is about just another bite at the apple to try to get the SIC report voided, which ultimately doesn't matter because it is what it is. A committee is allowed to report what a committee is allowed to report. The proof is out there.
First respondent going second, and then another round of questioning by the Judicial Committee if they so desire.
Mr. Chair, could you repeat that order, please?
Jake, this is the third JC appeal. One got resolved without hearing.
Okay. Okay. So if let me ask the parties if everybody is present whom they want to be present. Mr. Appellant, that would be, I guess, Mr. McGee.
That's Mr. Campbell.
I'm sorry, you're right, Mr. Campbell. Mr. Campbell, is everyone you need present?
Yeah, I'm here.
Okay, and the same for you, Mr. McGee?
Mr. McGee is here.
Okay, if you have everybody here you need, then Mr. Campbell, please go ahead. You have 10 minutes opening statement, and you can reserve time to rebut if you like.
Thank you. Members of the Judicial Committee, first of all, thank you for your service. Over the course of this term, you have been asked to review a significant number of difficult and often contentious disputes.
Once again.
This case may well be the final appeal before the upcoming national convention, and it presents an opportunity to provide clear ruling on an issue that has recurred throughout this term. You now have the benefit not only of the parties' briefs, but also two amicus filings, one by Karen Ann Harlos and one Hector Roos, which frame the competing interpretations of the
I haven't seen
LNC's
Hector's,
authority
but I
and the
wouldn't read
procedural
Hector's
requirements
anyway,
at
to be
issue.
honest with you.
This case asks a fundamental question. Can the LNC impose discipline
It wasn't
without
discipline.
calling it discipline and avoid the rules that discipline requires? But before reaching that question, there's a simpler one that may resolve the case entirely. Was there valid notice of the June
Notice was
9th
already
meeting
dealt
at
with
all?
in a prior
The
hearing.
LNC called a special meeting on June 2nd to adopt the SIC report. But at that moment, the SIC report did not exist.
That
It
doesn't
would not
matter.
exist until the SIC met on June 7th.
That's not how notice works.
The report was then
know.
provided
He does
less than
not know
48
Roberts. He
hours
admitted that
before the June
yesterday.
9th meeting. This is not just a timing issue. It is a notice failure at its core. Because notice requires informing members what they're being asked to consider. And here, the answer is unavoidable. How can notice be valid when the thing being noticed does not yet exist? I would invite the respondent to answer that question directly. Because if the answer is that notice was still
He's
valid,
also
the
misunderstanding
notice no longer requires
the
content,
difference
only a
between
placeholder.
previous notice. He doesn't
And that is not
understand special
consistent with
rules of
Robert's rules
order.
or basic principles of deliberative governance. The
You know,
issue
oh my God,
was not
Jesse, I watched you
emphasized
try to
in the
chair a
initial
convention
petition,
yesterday.
but was developed in the reply once the record was clear. June 2nd, meeting called. June 7th, report created. Less than 48 hours, time for review. But more fundamentally, the notice was incomplete at the moment it was given. But importantly, the LNC itself recognized a notice defect. It voided its own June 9th resolutions. That alone provides a clear and narrow basis for this committee to act. If the committee wishes, it can resolve this case on that ground alone. Insufficient notice. That is a straightforward, well-established basis to void LNC actions.
He doesn't
without
understand our
reaching the
policy
broader
manual.
disciplinary question.
He does not
But
understand
even
the
if the
role
committee does reach
of
that
special
question,
rules of
the
order.
answer is the same. The
Our
SIC
policy
process
manual
investigated
requires a
alleged
complete
misconduct,
text
made
for
findings,
original main
declared
motions,
an
not
individual
incidental main
unfit,
motions.
and
Jesse
imposed
could not explain
consequences.
to you the difference
That is discipline
between
in
an original main
substance.
motion and
And it
an
was not done
incidental main
without
motion.
charges, without notice of disciplinary notice,
It wasn't
without
discipline.
hearing. Sorry, it was done. Pardon me. The amicus filings illustrated this clearly, using prior LNC examples that the SIC departed from the standard by, taking actions that were not expressly authorized in the motion that created the SIC, such as making recommendations, adjudicating misconduct, and defining it in terms of violations of law, suggested disciplinary measures that consisted of real consequences and not merely opinion. So the committee is presented with two
Even
paths.
a judge
The narrow
has an
path,
opinion.
invalidate the action for lack of notice. The broader path, recognize that discipline occurred without due process. Either path leads to the same result. Under the bylaws, the policy manual, and Robert's rules, these actions cannot stand, and they must be declared null and void. Thank you. I reserve my remaining time for rebuttal.
Sorry, I have something else I have to take
Okay,
care
you
of.
used about 4.5 minutes. Mr. McGee, your opening statement.
Thank you. Members of the National Judicial Committee. The LNC respectfully submits this statement in response to the petition before you. The statement is provided to outline the factual background, committee actions, adopted resolutions, and to address the petitioner's claims regarding disciplinary standards, notice requirements, and due process as established by the party's bylaws, the policy manual, and Robert's Rules of Order. The purpose is to ensure an accurate account of the proceedings and to demonstrate the LNC's commitment to procedural integrity in all its actions. This is the third time that this matter has come before you, so I won't belabor the factual background, except to emphasize the relevant factual background for this case. The formal disciplinary process for Angela McArdle began on January 23rd, 2025.
I'm going to leave
when
this
the LNC opened an email.
Did he drop out?
Email ballot to form a formal disciplinary investigatory committee. The proposed committee was tasked with investigating the allegations of misconduct against Ms. McArdle. Just 2 days later, on January 25th, Ms. McArdle submitted her formal resignation as chair of the Libertarian Party, a move that significantly shifted the priority of the National Committee's focus. On January the 30th, the original motion to create the Disciplinary Investigatory Committee passed unanimously by a vote of 14-0-0 to not voting.
You have to have a Zoom account. I'm not sure.
On the meeting of February the 2nd, 2025, the LNC recognized the need for a separate inquiry and established a special investigatory committee to examine issues involving conflict of interest and business practices within the committee itself. Shortly thereafter, on February the 10th, a new email ballot was opened proposing to discharge the original disciplinary investigatory committee, arguing its purpose was now moot given that both McArdle's resignation and the establishment of the SIC, the motion passed on February 17th, again by a unanimous vote, this time 13 votes for not voting. effectively closing the original disciplinary inquiry and handing all investigative responsibilities to the SIC. As for the argument from the petitioner that the report did not exist at the time that the meeting was called on June the 2nd, that is not true. The report existed, it just had not been approved. There's an important distinction there. You can't just generate a 100-page report in a couple days. It doesn't happen. The conclusions were already there. It was just a matter of getting the committee members together to adopt it, which they did. All right. So the argument put forth by the petitioner is contingent on the disciplinary and substance standard of discipline. Without it, the entire argument fails. In essence, the argument of the petitioner is that anything disciplinary in substance is in fact disciplinary action under the bylaws, policy manual, and RONR. As such, anything determined to be disciplinary in substance requires disciplinary notice, charges, and fair procedure. Applied to this situation at hand, the argument is that the SIC report and its pertinent resolutions were disciplinary in substance, and thus their adoptions were disciplinary actions requiring disciplinary notice, charges, and fair procedure.
Jonathan writes
the thesis of the disciplinary and substance standard is set forth by the petitioner is that discipline is determined by substance, not label. The implication is that the National Committee is using mere semantic labels to get around disciplinary requirements. By implication, the petitioner is manufacturing the intent of the committee. Discipline is determined by procedural instrument, not by a vague notion of substance. RONR provides specifically for disciplinary and non-disciplinary actions. The National Committee has adhered faithfully to using the correct procedural instrument. While Mr. McArdle was on the National Committee, the priority was to pursue disciplinary action. Once Ms. McArdle resigned, that priority explicitly shifted. The SIC report, however harsh, is not the same thing as disciplinary action.
Correct.
It is merely the sincere report of the committee members who spent months trying to get to the bottom of the situation. At the heart of this appeal is the fact that the National Committee acted within its authority by investigating matters under its jurisdiction and adopting resolutions that express its findings and opinions.
Yes.
After Ms. McArdle's resignation, the LNC received the SIC report and passed resolutions stating that her conduct fell below the party's expected standards. Importantly, these resolutions did not impose any formal disciplinary sanctions such as suspension or expulsion, nor did they revoke any member rights that would trigger a disciplinary process under the bylaws, the policy manual, or Robert's Rules of Order. The petitioner's characterization of the LNC's actions as disciplinary in substance is imprecise and rhetorical. Ironically, terms like de facto penalties, functional disqualification, and repackaged discipline are mere flourish without meaningful substance.
Correct.
The petitioner further mischaracterizes the LNC response to manufacture a concession. In Section 7 of the petitioner's reply, the petitioner asserts that the LNC admits uncertainty regarding what protections apply to members and quotes a truncated fragment. It is unclear whether a general member of the party would be entitled to the same member rights. This is misleading and a misleading presentation of the record. The full quote in context reads, based on the argument provided by the petitioner, it is unclear whether a general member of the party would be entitled to the same member rights and disciplinary procedures
as an LNC member. He cut out.
As National Committee members, these rules. It was demonstrating the vagueness and impracticality of the petitioner's own disciplinary and substance framework. The petitioner's selective quotation distorts the National Committee's criticism into an admission. No such concession was offered. Relevant precedents such as Phillies v. LNC and Harlos are distinct from the current situation. In those cases, disciplinary processes and member removal was central, whereas in McArdle's case, she had already resigned and the LNC's resolution served only to record its conclusions about past events and issue a non-disciplinary censure.
And they censured
Therefore, the factual and procedural contexts are materially different, supporting the LNC's position that its actions did not constitute disciplinary measures requiring formal procedures.
In fact, even without resigning,
if the Judicial Committee were to accept the petitioner's vague disciplinary and substance standard, the National Committee would be hamstrung in its ability to address or even comment on conduct it finds concerning, unless it initiated a formal disciplinary trial. Since the LNC does not have the authority to impose formal discipline on party members, that's a power reserved specifically for National Convention delegates, This standard would force the LNC into silence whenever it discovers potential wrongdoing among National Committee members. Members that I remind you are charged while in office to uphold fiduciary duty to the party. Such an unreasonable standard would not only restrict the expression rights of the party's elected leaders, but also violate the LNC's governing rules, as it would prevent them from even voicing their opinions or findings in response to misconduct. The LNC has a fiduciary duty to safeguard the party's reputation, finances, and integrity. Under the petitioner's framework, the LNC faces a no-win scenario. If it investigates and expresses concern, it risks being accused of imposing de facto discipline without due process. If it remains silent, it fails in its obligation to the party's membership. Historically, the LNC has published negative reports and issued censures, such as in the cases involving former Chair Joe Bishop Henchman and Assemblyman John Moore, without these actions being considered disciplinary in substance or requiring formal trials. These precedents illustrate that strong expressions of opinion or findings have not previously been treated as disciplinary actions necessitating procedural safeguards. In conclusion, the LNC asserts that its actions following Ms. McCardle's resignation, specifically the SIC investigation and its resolutions, were permissible expressions of opinion and not formal disciplinary measures. The petitioners claim that these actions were disciplinary in substance and thus required no discharges and due process under party rules is challenged, with the LNC emphasizing its adherence to proper procedural instruments and distinguishing its actions from disciplinary precedents. The LNC argues that accepting the petitioner's vague standard would restrict its ability to fulfill fiduciary duties and express concerns about misconduct, ultimately undermining the committee's governance and integrity. Past cases, including negative reports and censures, demonstrate that strong opinions or findings have not been treated as disciplinary actions requiring formal procedures, supporting the LNC's position in this appeal. I welcome the questions of the committee.
Okay, thank you, Mr. McGee. Mr. Campbell, do you have a reply?
Yes, thank you. I don't think that it is without substance that the SIC findings were punitive in nature. Things like censures are punitive.
But you're
and
allowed
they require
to
formal hearings.
No, they don't.
And
no,
notice for that is really important, especially where the subject of the hearing is really important, because maybe that changes maybe the respondent's strategy with how they respond to such things, if they even show up in the first place and answer questions on something, because maybe they had information on a specific
she was
case that
asked
they would
to
really like
interview
to
with
share.
the SIC and she refused.
So I don't think it is without substance to say that there wasn't a
and she wouldn't
substantive
have to go to a disciplinary
need
hearing. You
for
can't
due
compel it.
process. It's substantive because the findings were punitive in nature. It is procedurally flawed because of the fact that it was without notice. So substantively, she should have been given notice of what to respond to, and procedurally, the notice itself is necessary within the bylaws.
No, it's not.
So that's just what I want to clear up. Thank you. I yield my remaining time.
Okay, thank you, Mr. Campbell. Questions by the Judicial Committee. First up, Mr. Krawchuk. Mr. Krawchuk, you appear to be muted or something. Can't hear you. Cannot hear you, Mr. Krawchuk. Okay, Mr. Krawchuk appears to be having some kind of technical difficulty. Let's move on to Mr. Seebeck, and we'll come back to Mr. Krawchuk.
All righty. These are questions primarily from Mr. Campbell. First question, how and where does Roberts define an original main motion?
Good question.
An original main motion?
An original main motion.
I mean, I can start going through the contents here and start looking for that, but I don't know the Robert's rules that well back off the top of my head.
I told you.
10.3, where it indicates that a main motion introduces a substantive question on as a new subject. So how does Roberts define it? How does Roberts define an incidental main motion?
I mean, again, that's getting into I'm not an expert on Robert's rules.
Then why are you appealing under Roberts?
Right.
10.4 indicates that a main motion is incidental to or relates to the business of the assembly or its past or future action. The recommendations from the SIC, were the original main motions or incidental main motions, and why?
I don't want to put the chat pop-ups.
I would say it'd be an original main motion because it's bringing a new subject before the assembly of consideration.
No, adoption of a committee
report.
Except for
the fact that the subject was brought forth to the committee for consideration when they voted to establish the SIC in the first place. And per Roberts 10.5, an incidental main motion involving a subject already introduced might include a motion to adopt recommendations which a committee has prepared upon instructions. That's in 10.5. What's the policy manual say about original main motions?
He's getting savaged.
I think a big piece of this hinges on the fact that
you don't know what you're talking about.
The goal of this shifted from when she resigned to being more disciplinary. Don't let him dodge it. So it's really just a matter of timing here.
That's not answering the question. What does the policy manual say about it? About the notice for original main motions?
And the policy manual says that that original main motions require previous notice.
And this was an incidental main motion.
What does it say about incidental main motions?
I don't think they say anything.
Exactly, they don't. So this was an incidental main motion to adopt the report. Therefore, notice, according to the policy manual, wasn't required.
Not notice in that sense.
So where would notice be covered on this then?
Jesse, you don't know what you're talking about. You should have had somebody else do this.
The SIC report was an original main motion because it departed from its original authorization.
A committee is allowed to do that.
Because the original motion had to do with establishment of the SIC to examine issues of ethics and practices of the actual entire LNC. And they did that because the report also included information regarding a couple other LNC members, including Mr. Ford. The actual application for notice is in Roberts 9.15, and that's where it says that notice is included in call of the meeting, but it doesn't preclude the consideration of privileged motions or any specific or other motions that may arise in connection with the transaction of such business or the conduct of the meeting. And that this requirement, this is 9.16, that business transacted at a special meeting be specified in the call should not be confused with the requirement that previous notice of a motion be given. Although the call of a special meeting must state purpose of the meeting, it doesn't need to give the exact content of individual motions to be considered.
Exactly.
When motions related to business is specified in the call of special meeting is pending, it is fully open to germane amendments as if it had been moved at a regular meeting. So again, what does Roberts say for notice from incidental main motions? It's in 1047. Unless the rules require full text of a motion, a resolution, or bylaw amendment be submitted within the notice, only the purport need to be indicated, but such a statement of purport must be accurate and complete.
He's going to argue that it's not accurate.
But the original notice was for investigations, not for discipline.
It wasn't discipline. You are putting the cart before the horse.
Did not the committee do investigations?
They did investigations and then discipline.
They did no discipline.
No, they did not. They recommended things. They did not impose anything. And as a nature of the committee, it is their job to make recommendations or to propose resolutions.
And if you're going to argue about notice of the app participant,
for which the LNC
resolutions,
acted on.
that was cured.
And that was crystal clear in the wording of the SIC itself. Because here's a simple question about it. Okay, if the report called them recommendations, are they original main motions or are they incidentals again?
Nathan, I don't know.
And again, this goes back to notice.
I think just substantively, really what I
Not
want to hammer
anything,
here
but that's
is
a bit
that
beyond what we can talk about today.
the motion to adopt the SIC report was an original main motion
No, it
because it
wasn't.
departed from its original authorization.
No, it wasn't.
It actually didn't. But 1047 specifically says that incidental main motions have specific notice applications, and the question is, were those met because they were 7 days in advance of the call in the meeting? I would say the answer to that is yes. Does a censure require disciplinary procedures? Mr. Campbell, you're muted.
Sorry, thank you. Not if the censure were the only option.
That's not what it says.
Or sorry, opinion.
Okay, and what's the basis for that, for that possibility?
I'm sorry, you mean like the basis of the censure?
No, you said it doesn't have to be, it would need disciplinary procedures if there were other options besides censure, if I heard you correctly.
I think it just depends on the content of the censure.
I need to do my nails. They are.
All right. Roberts 39.7, it touches on this very clearly. It says, except as may be necessary in the case of a motion of censure or a motion related to a disciplinary procedures, a motion must not use language flex on the member's conduct or character, et cetera, and so on. Also, 61.2 footnote 1, which I know that Mr. McGee mentioned in his LNC response, it's also possible to adopt a motion without formal disciplinary procedures, which is what happened in this case. So here's the next question. What happened to Joshua Smith in 2022?
I'm sure you can bring up something relevant.
He was censured by the LNC without a disciplinary process.
So was Arvin Bower, by the way.
He was censored by the LNC without disciplinary process. Some of the current members of the LNC are still there when that happened. So there is precedent when not requiring a disciplinary process.
Arvin Bower was too.
Did Ms. McArdle resign prior to the SIC report being adopted?
Right. And then the focus of the SIC shifted, as was stated earlier. And the motion of censure can express opinion, but once it says that a disciplinary conclusion does it trigger due process protections?
No, and the LNC cannot do that for members.
The
convention can take
still
this
on the
up.
LNC at the time that the recommendations were adopted?
No.
Then what due process requirements or the bylaws and the policy manual came into play?
Check my notes. Are you asking for like what rule?
Yes. If the allegation is they violated the rule, then it needs to be a citation of the rule they violated.
Second. I think I'm looking at the due process protections under Robert's rules, the rule for censures.
But it wasn't a disciplinary censure.
Except we've already covered that, and I asked about the policy manual of the bylaws.
I'm sorry.
He asked
Except
for
I
the
asked about the
policy
bylaws
manual
and
or the
policy
bylaws.
manual, not Roberts. Roberts we already covered with 61(2) footnote 1.
Right.
Well, I'll say this is good practice for Jesse with a good, for court cases. He's a new attorney.
So you want me to, I don't know. I can't find it in my notes right now. In the policy manual for
Yeah.
Or the bylaws.
And the bylaws.
for the bylaws.
Or both.
Mm-hmm. Yeah, he's running an AI search.
I mean, if it's not covered, hold on, I'm just looking. If it's not covered, it would have to revert to Robert's rules.
But you already covered Roberts, which allows censure without a disciplinary
Hold on.
process. AI doesn't take that long, Jesse.
Article 7, sections 5 through 6.
That's LNC members.
And the bylaws article under 16.
16
and
is Roberts
policy
as the
manual
parliamentary authority.
subsections 101.4, 107.2 through 5. Under the Libertarian Party bylaws, special rules of order, and the party's adopted parliamentarian authority, disciplinary actions include censure, suspension, expulsion, and other sanctions that formally condemn a member's conduct or restrict a participation or eligibility.
But does that discount the ability under Roberts to have a disciplinary or a censure without disciplinary process? Because it's already been done before by the LNC, multiple cases. And if they already can do it,
Yes.
then how is that exceeding their authority?
I don't think so. This is through the bylaws, and a lot of the things here are essential for substantive and procedural due process. That being a procedural right, and there just simply wasn't the same proper notice because of the subject of the SIC. And it's the rules to protect the members. Joshua Smith didn't complain about his censure, or just because Joshua Smith didn't complain about his censure doesn't mean that it justifies the action here.
Maybe it does, maybe it doesn't. Let me ask you one more question. Where do you think I got all these questions from?
No idea.
My previous opinion in this case, specifically paragraphs 41 through 68. It's a good idea when you guys do your research on these cases, if there's a previous opinion or opinions, that you read them, because you might find that what's already there already answers your questions. That's all from me, Mr. Chair.
Okay, thank you, Mr. Stiebeck. Mr. Krawchuk, have you fixed your technical issue?
FBI, I'd like to report a murder.
Maybe yes, maybe no. Can you hear me?
We can hear you.
I can hear you.
All right. Well, it's half fixed. I don't have video. I only have audio. All right. Close enough. You won't see me making faces at you. Okay. Mr. Campbell, just a question. Did you write that appeal?
By myself, no, I had a lot of help, but I put it all together. Just needed help with like the bylaws and stuff like that. But yeah, I wrote it.
Did you use
Okay.
AI?
Well, regarding the bylaws, outside of a convention, what is the authority of the Judicial Committee?
I'm sorry?
Outside of a convention, what is the
Jake,
authority of the Judicial Committee? What can we do?
Campbell.
I think you guys can do a lot of power. I mean, you guys have a lot of power here. You can follow whatever policy you guys want to present here. I mean, you guys have a lot of power.
Well, what actions can we perform?
He's
I mean,
so
specific, it's hard
unprepared.
to
He's so
enumerate
unprepared.
line item by line item. Is
I
like, are you looking
think
under the
the only one
bylaws? Like, because I mean, what we're looking for is voiding the action of the LNC that violate the bylaws.
Okay. All right, because outside of a convention, that's pretty much all we can do is to nullify a decision of the LNC. I have in front of me your prayer for relief, the things that you wanted to. Number 1, declaratory relief. Declare that the challenge actions were disciplinary in substance. Sir, we don't do that. We don't give any kind of declarations or anything. We only nullify decisions of the LNC or not.
Mm-hmm.
Which is why I was asking why was that in there?
I mean, maybe a Hail Mary. This is something that I feel is necessary to hash out here with the JC, because
Jesse,
I mean,
go
if
home. You're
the
drunk.
JC is
I
looking
don't mean that
at,
literally.
just with doubling down on prior readings, whatever, you can do that. Or you can look at the fact that this is just a procedure, due process issue that is like really the crux of what bylaws are supposed to do. We're supposed to play all by the same rules.
The bylaws
And
can
if
deny. Never
the
mind.
first notice that was given is about investigatory committees, and
I
then
know,
actual
Jake. Is it bad that
discipline
I'm
in
missing
substance was handed
Austin Martin
down,
right now?
and a potential respondent wasn't given the kind of
I'm
notice that
having
maybe, hey, you
secondhand
should
embarrassment.
come look at this. I think it's really important to have some sort of opinion. I guess like some sort of opinion that procedure will be followed, and that could be like administrative.
Okay, it's beyond our authority to just go and declare stuff like that. We can choose to veto something, and internally we may discuss something like that, but it's outside the scope of our powers. Next one, number 2 and number 3, a partial veto and full veto. Again, what we do is we will nullify decisions of the LNC. I did not see the decisions listed in your appeal. I checked out the footnotes, and there are all kinds of motions that are in there. Some of them seem germane, some of them didn't. Are we supposed to pick and choose which ones we nullify? Why did I miss seeing the list of what you want, specifically what you want it nullified?
I'm sorry, where are you looking?
Well, I'm still under your remedies requested, numbers 2 and 3, a partial veto and a full veto of those resolutions or directives that purport to impose disciplinary action. And again, my statement is, when I went through your appeal, I did not find a list of those decisions that you want nullified. And I went, and you had a bibliography there at the end with all the different minutes and everything. I went and looked at them, and there were a lot of decisions in there.
Committee report.
And
committee
I really came away saying, which one should we nullify?
The JC
Are we
has
supposed
no
to
authority
guess?
to nullify
Do we pick
a
and
committee
choose?
report.
How are we supposed to know what to nullify?
I'm looking at the relief requested right now.
I'm sorry, I cannot hear you.
I'm looking at it right now. Petitioners respectfully request that the Judicial Committee grant such relief as to the adoption of the Special Investigatory Committee report and all actions taken thereupon by the Libertarian National Committee at its June 9th, 2025 special meeting. The new SIC-related resolutions from August 24th, 2025, and any later actions that rely on these actions made before any ruling on this matter as it deems appropriate, including one or more of the following. That's under section 7.
Uh-huh. Okay.
It's just
Still seems a bit vague.
You know, there was more than just
Again, I was looking for something substantive. Here's a list of
if you're
things
looking
that we thought was wrong.
No, I mean, I'm not looking to down any hills. We're any relief that the Judicial Committee can give us, really. I mean, if you're telling me that's something that the JC can't do, then I'm not here to try to die on that hill. But if you're saying that,
Well, again,
avoiding the decision, then I would like that, yes.
okay, but we only would nullify decisions, and again, I didn't see a list, only a general statement of anything that may or may not have applied. And I'm not smart enough to pick out all those things that you feel are important. I might wind up picking out things that I think are important that you wouldn't. So I just didn't see that list. Moving on to number 4, prospective clarification. Prospective guidance. Again, we don't do prospective guidance. We look at everything fresh. And that's another thing. You refer back to some of the prior decisions, and Mr. Seebeck was correct. You can go back there and look for guidance on things that he has said before, but every one of these is brand new. There's no.
See, I don't agree with Ken there.
Prior
they're
history. There's no,
they're not brand new.
And
so
any
they're
kind
not
of precedent
100%
we are required to follow.
But they are persuasive.
So again, you're asking for things that we don't do.
The greater persuasiveness.
And when you get to number 5, other relief, grant other and further relief. That sounds like something an attorney wrote. Are you an attorney?
I'm an attorney, yes.
Okay, it shows.
Sorry, I wasn't
All right,
trying to.
well, that's it.
Sorry.
Ken doesn't like attorneys.
I know, because again, it seems like you did not read the section of our bylaws about what the Judicial Committee does, because all this is just, it's vague. It's stuff we don't do.
Yeah, I mean, the hill that I want down is that the notice is voidable. That's the crux of why I'm here today.
That was already decided in Jacob's.
Well, whether or not it is or isn't, we only have the power to say that. All right, I think I'm done. It's just that I just didn't have enough information to do anything. And just to let you know, when it first came in, I thought it just wasn't sufficient enough, detailed enough for an appeal.
I think,
and I would have.
Right. I agree with Ken.
I think it's just important to say any action taken by the LNC based on insufficient notice is voidable. That's what's being asked. It's a lot of actions. That is true. Yes. But yeah, that's what we want.
Okay. All right. Well, thank you very much for the answers, sir.
Of course.
Okay. Thank you, Mr. Krawchuk. I'm up next. And as long as we were talking about the notice before, I'll start with that. I basically have 4 points that I want to investigate. I think implicit in what Mr. Seebeck was asking is that there's a difference between prior notice and notice for the call of a special meeting.
Yes, Blaise, correct. And the LNC only requires prior notice.
I'm not sure
on original motions.
If there's any, it seemed that you were trying to say that there should have been prior notice, but I think Mr. Seebeck is probably correct that that this was incidental.
It is.
I mean, the LNC created an SIC. The SIC came in. The SIC was producing a report. I don't think any prior notice was necessary to consider the report, but there is notice that is required in the call of a meeting. I mean, a special meeting. I think Mr. Seebeck may have read this, but let me just read it again.
The policy
this is from Roberts 916. The requirement that business transacted at a special meeting be specified in the call should not be confused with the requirement that previous notice of a motion be given. Okay, so I don't think that the previous notice was necessary, but the call of the meeting has to have, I mean, what the business that's transacted at a special meeting has to be within the notice. So my first question is, I think let's see, where was it? Respondents, in respondents, in respondents brief, geez, where is it? Page 8, I believe. It says that the full text of the motions of censure were provided in the call of the August 24th special meeting. Mr. Campbell, do you know if that's true?
It is true. It is true.
I'm sorry, page 8 of the respondents?
Of the respondents brief. Let me Campbell respondents brief page.
I need to start. I know I don't like wearing my glasses all the time. Maybe it's vanity in these things, but I've noticed on a lot of my videos I'm really squinty because
it says here
I don't have my glasses
second to last paragraph.
I have to wear different glasses depending
regarding
upon
the
distance. These
ultimately
aren't my
adopted resolutions.
glasses. These are my
right, and these are the resolutions
glasses.
regarding the alleged wrongdoing by Ms. McCardle. The full text of the resolutions was provided at the call to the August 24th special meeting in Chair Nikhil's response to Mr. Bowler's point of order.
Yes.
Do you dispute that? Or do you admit that the text of the resolutions that were adopted at the August 24th meeting were in the call of the meeting?
I'm sorry, if I may ask to clarify, dispute what specifically?
Oh my God.
This statement in respondent's
I'm having
brief.
secondhand embarrassment so bad.
Alleging here that the full text of the resolutions that were voted on the August 24th meeting were in the call of the meeting, right? At the August 24th meeting, resolutions were passed. This is my wording, condemning certain actions by Ms. McCardle.
Censuring. They specifically used the word censure.
Resolutions were voted on at that meeting. Was the full text of those resolutions provided in the call for the meeting?
I dispute that the disciplinary nature of the report was disclosed, or that the disciplinary nature of the report was disclosed.
I'm not talking.
It would be disciplinary in substance.
I'm not talking about the report. I'm talking about the motions that were voted on. The report was adopted in the June 9th meeting, correct?
And there was an attempt to rescind
the motions were
the
voted by
adoption
point
of the
order.
report.
In the June 9th meeting.
Yes.
Okay. What about the August 24th meeting? Was there another meeting? Was there a second meeting on August 24th?
Yes.
And at that meeting, were those same motions that were voided in the June 9th meeting, were those same motions again put forward in the August 24th meeting?
They were not the same motions, but
they
depending on the report.
They were slightly changed.
The motions,
in order.
the motions censuring Ms. McCardle. You're saying there were no motions censuring Ms. McCardle in the August 24th meeting?
I'm saying, am I saying that I'm saying that or not saying that?
Oh my God.
Mr. McGee, maybe you can help us out here. Were there motions passed censuring Ms. McCardle at the August 24th meeting?
Yes, there were. There were two. While the wording may not have been the exact same as the ones passed the June 9th meeting, they were resolutions similar in nature, but with different wording.
Yeah, right. I agree. They did censure, but not in the same way. Thank you.
Okay, were the motions that were
You
passed
should have
at the
mentioned that
August
the wording was
24th meeting
changed in order to
was
satisfy the
the
Jacobs v. LNC
precise
appeal.
text of those motions specified in the call of the meeting?
Yes.
Mr. P. They
yes, absolutely. Specifically in response to Mr. Bowler. In fact, I posted that in my factual background in my brief. If you scroll back up to pages 3 and 4 of my brief, you can see the exact wording of Mr. Nikela in response to Mr. Bowler. And the full text of both resolutions is present.
Okay. Mr. Campbell, do you agree that the full text of the motions that were passed, and by the way, Mr. McGee, those motions were passed at the August 24th meeting, is that correct?
That is correct, sir.
Okay. So, Mr. Campbell, do you agree that the motions that were passed at the August 24th meeting, that the text of those motions was provided in the call of the August 24th meeting? You concede that, or do you dispute that?
Let me look at my notes here. I mean, if you want me to look at that right now, yeah, hold on. Sorry.
You know, it's all right. Let me just ask you this. Would you concede that there is no failure of notice if the text of those motions that were passed at the August 24th meeting were in the call of the August 24th meeting? Follow that?
If they were in the call of the August 24th meeting?
Yes, I mean, this is a factual question. Either the text of the motions that were passed at the August 24th meeting were in the call of the August 24th meeting, or they were not in the call. Would you concede that if they were in the call of the August 24th meeting, that notice was satisfied, or do you think there is some other basis for questioning the notice in this case?
The August 24th resolutions were in the call of the meeting, but they can be voidable still.
On what basis?
The SIC report adoption failed the notice requirement, ergo any action dependent on the SIC report is also voidable.
That's not how it works, because the LNC does not have to adopt a committee report.
Okay.
If I may read the resolution.
I mean, I'm not sure that's true. I mean, if you're saying that they have to, that without the SIC report, there's no, they can't, that the LNC can't pass a motion of censure?
I think they skipped a step in doing what they did here.
Okay, well, let me ask this then. Do you think that that these motions of censure should have had a full trial?
Yes.
You hold that
yes.
that a trial was required in this case.
Yes. Yes.
So based on that, so basically you're saying that they can't pass these motions of censure without a full trial.
Well, so we're talking about the August 24th resolutions. If I just may read them into the record here.
If you like.
Resolution 1, whereas the Special Investigatory Committee has found that former Chair Angela McArdle engaged in actions that, in the LNC's view, violated fiduciary duties to the Libertarian Party, including concealing conflicts of interest and misusing donor funds. Now, therefore, it be resolved that the Libertarian National Committee censures Angela McArdle for conduct in violation of the fiduciary duties and ethical standards expected of party leaders. Be it further resolved that the Libertarian National Committee expresses its opinion that Angela McArdle's conduct, as detailed in the Special Investigatory Report, reflects behavior inconsistent with the standards expected of those serving in leadership roles of the Libertarian Party or as a candidate representing it. Resolution 2. Whereas the Special Investigatory Committee finds that former chair Angela McCardle
Right. The Special
financially
Investigatory Committee is
benefited
allowed
from
to
her
find
deception
whatever it
of the
finds.
Libertarian National
The
Committee,
JC has
be it
no
resolved
authority over
that
that
the Libertarian
and
National
doesn't have
Committee
any
shall explore
authority over
fundraising
whether the
and or pro
LNC
bono legal
believes that
counsel
report or
to
not.
pursue the recovery of funds under any legal procedures available as outlined in this report and any supplemental reports produced by the Special Investigatory Committee.
All right. I was just only trying to deal with the notice issue. You've brought up another issue, which is a reasonable issue, as to what steps are required to make a censure like this.
Right.
But in terms of just plain notice, can we dispense with the notice issue and say that there is no failure of notice here? Because I think there's also a second. Not only was the in terms of these motions of censure, not only was the text of the motions provided in the call of the meeting, but the fact that the report was passed at the June 9th meeting, and maybe that shouldn't have been passed at the June 9th meeting, but the fact that these motions were made in response to this, pertinent to this report. Now, I kind of agree with you that was somewhat of an ambush, right? You don't call a special meeting and say, hey, we're going to consider this report, and then put these draconian motions of censure on the table. You have to specify that in the call of the meeting. That's not what the meeting is called for. The meeting was not called for a disciplinary purpose. The meeting was called for the purpose of considering the report, and then these disciplinary things were,
they weren't disciplinary.
Were sprung on everybody. But given that happened the first time, and then those two resolutions were rescinded, and then they were repeated. I mean, you had the same thing happen again at the August 24th meeting, where they said we're going to consider this report, and then they sprung these two resolutions. Arguably, isn't just the mere fact that the same thing happened a month earlier, doesn't that really give you notice that this is what's planning to happen? I mean, even beside the fact that the actual text of the motions was in the call of the meeting, even without that, I think you'd have notice of what was going to happen, right? So, can we dispense with the issue of notice?
The August 24th resolutions were in the call of the meeting, but they can be voidable because it's dependent on the SIC report, which is adopted improperly. So yes.
But the SIC report was
What's that got to do with notice?
By the committee. It doesn't have to be adopted by the LNC.
It's the subject of the notice itself.
Okay, so okay, I'm going to take that as that you admit that there is no notice issue.
The notice issue of the SIC report can void actions later.
Well, obviously, you're saying there's a procedural problem. You're saying there is no procedural problem. There is no notice issue. The text of the first meeting, the June 9th meeting, there was notice of the report, right? We're going to consider this report. There's no notice issue. Everybody knew that a report was created. Everybody knew that the SIC itself was created, and that the SIC had a report, and everybody's expecting the fact that they're going to consider a report. That is fine notice, I would think. I don't see what the problem is. Isn't if you say we're going to consider the SIC report, even if the report hasn't been created yet, the SIC report is, you can even say it, the SIC report, which hasn't been created yet, it's going to be available in a couple of days, we're going to be considering adopting that report at the next meeting. Is there something wrong with that notice?
That the report hasn't even been created yet?
Yeah, if you say we're going to be created, the report's going to be created. It's going to be created 2 days before the meeting, and at this meeting, we're going to be considering adoption of the report. Is there a problem with
I
that?
think Wayne just came home.
Right. Well, the SIC report wasn't published to indicate that it was a valid report under the motion that created the SIC.
Committees
sorry,
are
I didn't
allowed to
follow
go
that.
beyond
Say
the
that again.
scope.
I'm sorry, it's a departure from the instructions. The SIC report wasn't published to indicate that it was a valid report under the motion that created the SIC. That made it an original main motion.
No, it didn't.
All right. I'm just talking about the call of the meeting. All right. A meeting is called saying we're going to consider this SIC report, and then at the meeting they adopted the SIC report. It seems to me that there's no issue of notice there. There may be other issues, but there's no issue of notice. You're saying we're going to adopt this report. The report comes in, you adopt the report. Then you also go on to create resolutions that are disciplinary in nature. That's a problem. Okay, but those were
They weren't
rescinded, and then those were dealt with later.
I mean, you're starting to get the lay of
in the later meeting,
now there's
there is no
JC
problem of
members
notice
not
because
here.
the first meeting,
I think Rob
you have
Stratton's
noticed that
not there,
this
and
is what
Mark
happened in the
Montoni's
first
not
meeting,
there.
so you know it's going to happen again in the second meeting. And to really put
But I
this
think
to
we
bed,
see
the
where at
text of
least two
the
JC members are
resolutions
gone, though
is
I've been
provided
wrong
in
on
the
this
call of the
before.
second meeting. So can we admit that there's no notice issue?
Yes, they never. Well,
I think that's a
Austin
different
Other
does.
issues,
notice
but not
standard.
notice.
Right. I think that I understand what you're saying. I think that's a different notice standard than what is suggested by the respondent to apply. I believe we're looking at in the policy manual 1.02. The call violated the previous notice requirement in 1.02 of the policy manual.
Okay. I'll call your attention again to Roberts 916. The requirement that business transacted at a special meeting be specified in the call should not be confused with a requirement that previous notice of a motion be given. Those are two different types of notice. I don't believe that
I
there
didn't
was
get
any
enough to drink.
necessity
If Wayne
for
is home,
I think I understand what you're
previous
saying.
notice of
maybe
of
they'll
these
do a
motions.
bathroom break.
Right.
Do I have
Well,
my
so I mean,
intermission
Robert's rules
graphics?
is available for when we don't have any idea what to do here through LNC or whoever or bylaws. But this is cleared up in the policy manual,
Right,
which supersedes Roberts in this moment because we have clarification from.
Okay, I'd like to move on. I think you're not applying the rules properly.
This is going to come down to the disciplinary issue, which it was not.
Previous
but I think
notice
we can see
is
how
not
this is
really
going.
at issue when you're talking about a special meeting. That's only, it says that that previous notice
He's not exactly
is necessary
correct, but he is
if the
correct
rules
in this
require it.
case.
There's no rule requiring previous notice for these things.
I
So
think
that
also,
whole doesn't.
Sorry.
Okay, I'm going to move on. I spent way more time on this than I wanted to.
Yeah, of course.
Let's talk for a minute about discipline. I guess this is for Mr. McGee. Would you say? Do you think can you really say with a straight face that these censure motions are not disciplinary?
Yes.
In the context of Roberts,
Yes.
yeah.
Yes.
There's a very specific
Disciplinary
distinction
is when
between
you get
what a disciplinary
deprived of
process is and
member
what
rights.
it isn't. There again, if we were talking about the only reason this is even an issue is because there are two different types of censure allowed in Roberts, which makes it censure unique when it comes to any
Plus, she
sort
had
of,
no rights
disciplinary or
deprived. If she had
non-disciplinary
rights
type of
deprived, I
procedure.
don't care what you call it.
Obviously, if
Censure, not
these
censure,
resolutions had
a peanut
attempted
butter
to
sandwich,
expel
it would
or
be disciplinary.
suspend
She had no rights.
Ms. McCardle from the
She had
LNC,
no rights denied.
that obviously would require a disciplinary process. And certainly one of the penalties after a
Now,
disciplinary
Blay
trial
is going to
is
grill
a
Jonathan on
disciplinary
this.
censure. But there is clear distinction, as outlined by Mr. Seebeck and in my respondent brief, between a motion of censure and a disciplinary censure. And I would argue that just
a disciplinary censure is usually when some member rights are trying to be taken away and the votes aren't there for that, and they settle for a censure.
News to me. I don't pretend to know every single thing about Roberts, but I was not aware that there are two different types of censure in Roberts. Do you have any kind of a cite for that?
It's in his brief.
Mr. Seebeck cited, I believe it's 39.7.
No.
And certainly I cited in my brief 61.2 footnote 1.
Yes.
Okay. Well, in 61.2, outside of footnote 1, it says punishments that a society can impose generally fall under the headings of censure, fine, if authorized in the bylaws, suspension, or expulsion.
Right.
So,
which I also
censure
outlined.
is a punishment. Censure is a punishment, is it not?
It can be.
In a disciplinary context, it is.
So there are kinds of censure that are not disciplinary?
Yes, that's what the footnote says,
well, okay, to go back to the example, I believe it was the question asked by Mr. Seebeck, if are there any provisions in the bylaws for, disciplinary action? And Mr. Campbell correctly cited several bylaws that do apply to relevant disciplinary action.
But it's only for LNC members.
The disciplinary action provided for in the bylaws only applies to LNC members. Once Ms. McCardle resigned, those regulations no longer become relevant, because there's no way that the LNC can actually pursue discipline against someone that is not a member of the LNC per the bylaws. And so the LNC's action was not in pursuit of that. His motion to censure, whereas a disciplinary censure can only apply to
an LNC
members of a specific body that is authorized for discipline, here being the LNC, a motion to censure can be against anyone. For example, the LNC could pass the motion to censure Donald Trump for starting for the war in Iran if they wanted to. Is that disciplinary in nature? I mean, is that really a credible argument?
You could say he's a war criminal.
Could the LNC censure a regular member of the party?
Yes.
They could pass a motion of censure, but they could not use a disciplinary censure.
Where do you see a distinction between disciplinary censure and non-disciplinary censure in Roberts or in the bylaws or anywhere else?
It's pretty clear from 39.7, because there is a distinguishment between. Let me pull up 39.7 for you just to try and make this clear. Okay, so 39.7. No motion can be introduced that is outside the object of the society as defined in the corporate charter, constitution, or bylaws, unless
he broke
by 2/3 vote, the assembly agrees to its case of a motion of censure, or a motion related to disciplinary procedures. A motion must not use language that reflects on a member's conduct or character, or is discourteous, unnecessarily harsh, or not allowed in debate. So this is a specific carve-out in Roberts for motions of censure that is distinct from disciplinary censure as laid out in section 61.
And then 61.2.1 specifically says there's a difference.
So you think that the LNC would have the authority to censure a member of the party who is
Yes.
not
They did that
a
with
member of
Assemblyman
the
John Moore.
LNC.
A motion of censure. There's no grounds for the LNC being able to actually pass disciplinary censure. Disciplinary censure is distinct from a motion of censure because it does require a disciplinary process.
They did it with Assemblyman John Moore and even asked him to
Section
return
63,
money.
as I outlined in my respondent brief.
All right. So you maintain that there are two different kinds of censure:
Roberts
a disciplinary
maintains
censure
that,
and a
Blair. You should
non-disciplinary
know
censure.
this.
Correct.
Okay. Oh, that's interesting. I never heard of that, but
Well, you should read it.
something I'll have to look into.
Yeah. Well, I hope you do look into
Okay.
it, Blair.
So I have two other points, questions. I guess this is for
That I don't
Mr.
know,
Campbell.
Jake. They might have before my time.
Did you have a chance to look at Ms. Harlow's amicus brief, Mr. Campbell?
Very briefly.
Well, she made some actual good points about bringing up. Would you say that this case is any different from the last case? I mean, how is this case? Have the facts in this case?
I'm available.
Are the facts in this case any different from the last one we decided? I mean, in other words, does it make sense for the JC to allow the same case to come before it again and again and again?
Are we saying that the disciplinary actions have any teeth or no teeth? Then I feel like
that wasn't his question.
What, you want to go back to the previous discussion?
Well, I mean, is this real or is this not? Are there any teeth to this action? If Angela came back tomorrow, joined the LNC, would there be any repercussions from this?
No.
The facts are different between my appeal brief and my
but I don't know. I'm not. That's not really not a question that's being posed here. So
I got back on the LNC.
I'm not sure.
When I had a prior LNC,
the facts are different between my
JC
appeal brief and my
vote to
reply
remove
brief.
me. It got overturned by convention, but it was still out there.
No, I'm saying that there was a case. Roos brought this same. Mr. Roos brought the same case to us a few months ago, and now it's before us again. Why weren't the arguments that you're making today brought up during
exactly? Correct here.
During the Roos appeal?
Why was my later writings different from my earlier?
Why didn't you bring these arguments up? You made an appeal
the same thing
recently, right? This appeal that we're hearing today. Why did you not bring these arguments up when Roos made his appeal?
I think that's probably a question for Mr. Roos.
No, it's a question for you. Why didn't you say, oh, I see Mr. Roos is making this appeal. I have some issues about this too. Let me join Mr. Roos in his appeal, or let me file an amicus brief or something. Why did you wait until the Roos appeal was decided, and now you're bringing a new appeal based on exactly the same facts? Why did you mention these facts last time we considered these facts? Right? Have the facts changed?
So it sounds like the question is, why did I bring up an appeal that wasn't available yet?
It was always available.
Right? Until
you're an attorney? You're an attorney, Mr. Campbell?
Yes.
Are you familiar with the concept of res judicata or claim preclusion, res judicata? Are you familiar with that concept?
Yeah.
Okay. the idea is that you don't get two bites at the apple normally, right? You know, in a real court, and I concede this is not a real court, you make your best case. You have to bring forward all your arguments. You can't keep a bunch of arguments in reserve, you know, and then ask for the court to hear it again, right? You have to put all your arguments in, and once the court has decided, you know, you got to make your best arguments and all your arguments. And once the court has made a decision, you can't 6 months later come back and say, "Hey, I want to have another trial based on the same facts." Isn't that what you're doing here?
I mean, well, no.
Yes.
But also the LNC is governed by the bylaws and the rules. If you're asking about res judicata, I mean, we got to talk about parties and facts, and I mean, if you want to apply like a legal standard, that's one thing, but we're talking about bylaws here.
What we're talking about here is a factual situation. People, Mr. Roos and others, did not like the fact that these resolutions were passed and that this report was passed, and he brought a case to void these resolutions. Now, 6 months later, you're bringing exactly the same facts to us, but with a different theory, a different legal theory.
Right.
Should that be allowed?
No.
Would that?
If you're it's a different.
Doesn't that open? Yeah. I'm sorry?
If you're saying we're talking about a different legal theory, yes, and also the facts are not all the same.
Yes, they are. Nothing's
They're
changed.
not. They're what facts are different? There was an SIC report passed on the 9th. You feel that on June 9th, you feel that SIC report was should not have been passed for, right? And you wanted that Mr. Roos wanted that SIC report voided, and
I don't think
resolutions of censure were passed on August 24th, and Mr. Roos wanted those voided. Aren't you asking for exactly the same thing, or
yes.
or it's based on the same factual
the same
scenario?
operative facts.
I'm not sure his mentions the call of the June 9th and notice issues.
JJ did.
The notice issue is your legal theory. It has nothing to do with the facts.
Exactly.
The facts haven't changed. Whatever notice there was then, it's the same notice now. There's no new discovery of a notice that people didn't know about.
I think if this were to happen again, even with the same everything and everybody's, if this were a new thing that
what were to happen again? I don't understand.
Like
another trial based on the third trial based on the same facts, or
I think if there was a third time that this happens again, where they say they're going to, like the notice given was that they're going to consider an investigatory report, and then they made the decision to adopt the investigatory report.
You're not addressing my question. Am I correct? You're saying if the LNC does the same thing again in some future case that they did now, what would we do in that case? Is that what you're saying? I'm saying this case. This is the second time this case has brought before us. Is there any reason why we should even entertain this case? We've already heard this case. These same exact facts came before us 6 months ago. Why should we hear exactly the same things again? Exactly the same facts. We've already heard these facts. Why would we listen to these facts again?
I think this one thing was obviously highly contentious, and it's gonna rustle a lot of jimmies. And I think There's a lot of different ways to look at this one thing that happened.
That's not answering the question.
I mean, there's different variables.
I'm sorry,
to
I
this
got
one
ADHD a
end
bit. I'm
conclusion.
reading blogs and Twitters. I have to a little bit.
So you're saying that here in the Libertarian Party, people should get 2 bites at the apple,
3.
as they say. You should get, if you bring a case before the Judicial Committee and you say, I don't like what the LNC did, I'm going to bring this case. If you don't get the answer you like, if the Judicial Committee rules for the LNC, then you can just come back again 6 months later or 4 months later or the next day
on the ground
and again say,
otherwise I never would have
Judicial
thought
Committee, we want you to
bring it
hear
again.
this case again.
I think
you can just keep doing that and doing that until we find in your favor, maybe just to make you go away. But once we find in the appellant's favor, the LNC can't really appeal. So, I mean, isn't this just a way to if we allow you to prosecute this appeal, which is based on exactly the same facts that were prosecuted 6 months ago, doesn't that open the door to perpetual appeal after appeal after appeal of the same issue until?
But yeah,
no. To answer your question, we're not
until you win.
We're not litigating the facts here. The difference here, I mean,
it's a legal theory.
To answer your question, like something can happen, you get arrested for, I don't know, burglary, but they decide, oh, on these facts, it's actually assaults and robbery. What, you know what I mean? Yeah, that can happen. And the JC didn't grant relief to Roos because he didn't ask for it. I don't, correct me if I'm wrong, but he didn't talk about the notice issue or the disciplinary nature of the actions.
I believe he did.
He did.
He had a whole thing about misrepresentation and everything. Yeah, he all of that stuff was brought up, but it's not the point. What arguments were made is not the point. The point is that we've already had a trial on this fact pattern, on these facts. Facts haven't changed, right? This is all stuff that happened in the past. The past doesn't change. Not in, maybe in communist countries the past changes, but not here. So, the question is, once you've had a trial, let's say, I don't want to cast any aspersions on anybody, but let's take a hypothetical. You have a trial based on facts, and the prosecutor does a lousy job. Okay, you don't get a great trial. Okay, and you lose. Should you be able to then bring it back and say, let's try it again
under a new theory?
If you didn't get notice of the trial, then yeah, you got to have proper notice.
Oh, you got notice of the trial.
Well, that depends. If you're having a trial on an assault,
you're saying you didn't get notice that there was a trial?
You got to have notice of what the substance of the trial is. If you get a summons and it's like, hey, you're looking at simple theft, but actually they hear robbery charges at that trial, that's not the same.
Let's not talk about a criminal case. Let's talk about you see your neighbor steal your lawnmower out of your yard, so you sue your neighbor, and you have a crappy attorney, and the judge says, nope, he didn't steal your lawnmower. Should you be able to bring the trial again with a new attorney and a new theory and say, hey, he stole my lawnmower? Should you be able to go back to court and say, or should the guy say, look, you've wasted enough of my time, okay? We had this trial, and it was found that I didn't steal his lawnmower, so why do I have to come back to court and defend myself again? Do you think you should be able to bring that same case twice?
I think if we're talking about lawnmowers here, if the reason is it wasn't his lawnmower and it's someone else's lawnmower, that guy could say, hey, yeah, actually, I want to sue this guy, though.
Well, let's say the court just made a mistake. They were wrong. It was your lawnmower, and the guy stole your lawnmower, but your attorney was an idiot, and he didn't ask the right questions or whatever. You know,
You can
and now
appeal
you've got
it,
a better attorney who's going to ask the right questions. Should you be able to bring the case again?
Notice actually can overthrow an entire case. Notice is a very, very important
I
fundamental
didn't mention anything about
process.
notice.
You ain't
This
talking
whole
didn't
about
thing,
mention
notice
notice.
here.
this thing is
Okay.
about
There's a let me ask Mr. McGee. Is the LNC concerned at all about this issue that of somebody bringing the same case over and over again based on the
Yes.
same facts, or are they not concerned with that? I mean, I could see maybe you say, well, it's not going to happen. It's probably never happened before. It's happening in this case because
It's never happened before because people
some
realize you
issues
can't
were
do
not
that.
brought up that could have been. You know, and so this is a special case. This isn't going to happen all the time, and we don't care. You know, or you may feel differently. Has the LNC considered this issue at all?
Actually, yes. And this is technically the first time that a case has been brought based on the same facts.
Yes.
Okay. And
certainly there have been changed. Where for example, in the case originally, Harlos won the challenge to the JFC, and then Mr. DeRazio's later challenge once circumstances regarding RFK changed. They're not the exact same facts, so you can't say that we're retrying the same thing because the fact patterns are not the same. In this case, the fact patterns are the same. The only thing that's different is the legal theory.
That's right. And so what's wrong with that? So what? So they can bring, so it's a different legal theory. Better, you know, we made a mistake in the first case. We did not get justice. You know, we need justice.
Campbell sign off on the first.
So we're bringing
on
this case again because we didn't get justice the first time. Something wrong with that?
Yes.
What?
It creates.
Mr. Chair, pardon me if I break in here. Let's stop talking about foreign bylaws, foreign rules. It doesn't matter what other courts do. The question is, what does Roberts say? What do our bylaws say? What does the policy manual say? Can you please abandon this line of discussion?
Pardon.
This is an issue regarding the propriety of bringing the same case over and over again to the Mr. Krawczyk, you're saying that there is no basis for questioning this? There's no issue of basic fairness or wasting the time of the Judicial Committee and the LNC over and over again? That there's no concern that the same case may be brought over and over again?
I beg your pardon.
Sir, I said at the beginning, you should not have accepted this appeal. You should not have accepted it.
I beg your pardon, Mr. Tarnoff, or Chair Tarnoff. I think perhaps Mr. Krawczyk only has about another half hour that he's available, and I think that may be why he's not inclined to continue this line of questioning.
All right, I'm gonna. Who said that, Mr. McGee? Okay, I'm gonna move on to my last issue if I can remember it. Yes, I would call your attention to is it 63.3? Is that it? Yes, 63.3 of Roberts, where it says, if after a trial a member is expelled or an officer is removed from office, the society has the right to disclose that fact, circulating it only to the extent required for the protection of the society or possibly of other organizations. And here's the important sentence. Neither the society nor any of its members has the right to make public the charge of which an officer or member has been found guilty or to reveal any other details connected with the case. My question is the
executive session rules
has the SIC report been made public?
It has.
To the entire world or just to the LP membership?
My understanding is it's public.
Public. And what about the motions of censure, the 2 or 3, I forget how many there were, motions of censure describing pretty serious allegations against Ms. McCardle? Have those also been made public?
I mean, they're in the minutes.
They're in the minutes, and anyone in the world can look at those minutes.
They're on the LP.org. Yes. The short answer is yes.
Okay, so what would you say about this second sentence here in 63.3? Neither the society nor any of its members has the right to make public the charge of which an officer or member has been found guilty, or to reveal any other details connected with the case.
This presupposes.
Don't you feel that you have violated that by publicizing these very serious charges against Ms. McCardle?
Again, this presupposes, in fact, Ronner 63 entirely presupposes disciplinary action. As I've already outlined to you, these motions of censure do not constitute disciplinary action and therefore not subject to Ronner 63.
Well, do these motions constitute a finding by the LNC of wrongdoing on the part of Ms. McCardle?
They constitute an opinion based on a special investigation by an ad hoc committee, neither of which constitutes disciplinary action.
Well, disciplinary action or not, okay, would you concede that if these statements regarding what Ms. McCardle allegedly did, or that the LNC believes she did, that if these are not true, they would be defamatory?
Absolutely. But Roberts allows motions to be in order that are potentially defamatory. If you look at actually, if you look at, in fact, this is actually mentioned by Mr. Jacobs in Jacobs v. LNC, his initial petition. He concedes that a original main motion can't be ruled out of order just because it's potentially libelous.
Yep.
I believe it's actually 1026
and 39.7.
Oh, that's interesting. That's probably true. Let's see, 1026. You know, I mean, yes, a body has the right to do things that are illegal,
right,
or defamatory, but it just says here that neither the society or any of its members has the right to make public the charge of it. I mean, if after a trial and a person has been found guilty of something,
but that's a trial,
you can't reveal what they did. Why can you reveal what they did without a trial?
Well, that has to do with the actual Ronner 63 process as a whole. In general, if you read if you understand the disciplinary process, the actual act of preferring charges or forming a committee to investigate, a disciplinary investigatory committee, is supposed to be, per Ronner, done in executive session so as to not expose a society to potential legal liability. However, our bylaws, specifically Article 715, precludes us from being able to make any such decision in executive session. Therefore, our bylaws necessarily preclude us being able to protect our society from legal liability through a disciplinary investigatory
Roberts.
That's why let's say Ms. McCardle had a trial,
yes,
right, and was found guilty of these charges. You're saying, and these motions, and the penalty was going to be these motions of censure, the exact same motions that were passed. Are you saying that
it had to be
that those motions could be ruled out of order because of 63.3, but the fact that she didn't have a trial means that the motions cannot be ruled out of order?
No, that's not what he's saying
at all. Could those motions be ruled out of order if she had a trial per Section 63 and the the penalty imposed was these exact motions of censure, could those be ruled out of
No.
order?
Because we have our
Under our
bylaws
current
supersede that.
bylaws, no.
They could not.
Correct.
But that has nothing to do with Ronner. If our bylaws didn't interfere, or supersede that provision in Ronner, you would hypothetically be correct. But that's not the way 715
Right.
reads. We're not allowed to make any decisions, any sort of decisions like applying a penalty. That's why in the trial of Karen Ann Harlos, while obviously this body ultimately ruled it out of order or overturned the decision of the LNC in that trial, the fact of the matter is that because of the bylaws, the actual charges, as well as the ultimate vote to suspend Ms. Harlos, was required to be done in open session.
And I didn't object to that.
Therefore, making it public. Therefore, making it in violation of Ronner 63.3.
Yeah.
So,
but I didn't object to that.
That's just our bylaws. That's a particular quirk of our bylaws.
Okay, so you're all right. Yeah, all right. I guess that's a reasonable point. But let me ask you a hypothetical. If we were to find that the LNC improperly publicized facts about Ms. Harlos, about Ms. McCardle, beyond the fact, there's no question the LNC has the absolute right to say Ms. McCardle is something like, Ms. McCardle has been censured for inappropriate activity as chair or improper financial whatever, something vague like that. But if the Judicial Committee were to find that the way these motions are worded, that it was not proper for the LNC to release that information to the public, what would be an appropriate remedy for that?
You can't void it based upon that. It doesn't violate the bylaws.
That's a vague hypothetical. It depends on what the basis for the JC ruling that is.
Would it make sense for the JC to, since there really is no other way to do it, to say that the motions are overturned because this information should not have been made public? Is reason that wouldn't make sense?
No.
I would respectfully disagree because of the arguments made here and in my responded brief, but certainly that's the purview of the JC.
Okay, I'm done. Is Mr. Montoni here?
I don't think he is.
Did Mr. Montoni ever come?
He has not.
I don't believe he is. Okay. Mr. Kinsella.
Yeah. I have nothing much to add. Your questions are really good along the line of res judicata. I guess I would just comment that I personally don't think it's appropriate for the JC to admonish members for knowing something about the law. And furthermore, I guess one JC member's opinion that there's no res judicata doesn't mean we're all bound by that. We have different opinions about how to rule according to justice and interpreting the bylaws. So that's all I'd say there.
Okay. I believe Mr. Stratton is not here. Mr. Latham, do you have any questions?
I do not for this round, Mr. Chairman.
Okay, well, that concludes the questioning by the Judicial Committee. The litigants now will have 5 minutes each for rebuttal, beginning with Mr. Campbell.
It usually goes the other way around.
Thank you. I think just overarching, just to kind of answer a lot of the lines of questioning, this is a Judicial Committee that is hearing this based off of the bylaws and justice. under the bylaws, I'm looking at policy manual 1.02.1. One, previous notice, an LNC member may satisfy the requirement of giving previous notice of their intention to introduce an original main motion at the next session by announcing this intention at the previous session in the presence of a quorum, providing an accurate and complete statement of purport with such notice to be taken note of the minutes, or sending the complete language of the motion to the entire LNC by email at least 5 days prior to the session. This being an original main motion because under Robert's Rules 1052, the motion to adopt the SIC report was an original main motion and subject to previous notice under the policy manual 1.021, because under 1052, a motion to adopt or accept a report or the recommendations of a standing committee prepared on the committee's
It's not
own
a standing committee.
and dealing with a subject that was not expressly referred to the committee, however,
it was an ad hoc
is an original
committee.
main motion. Now, at the close of this case, the issues are, I hope, clearer and narrower than they first appeared. You have before you not only the parties' arguments, but also 2 amicus briefs that sharpen the dispute. But despite that volume of argument, one question remains unanswered. How can notice be valid when the subject of the meeting did not exist at the time of the notice was given? The timeline is undisputed. June 2, meeting called. June 7, report created. Less than 48 hours provided to members. That is not meaningful notice. That is not an adequate preparation. That is not in compliance with the Libertarian Party's rules or values. And that alone is sufficient. The committee does not need to resolve every ambiguity raised in the briefs. It can decide that this case is on the clearest grounds available. The June 9 meeting was improperly noticed. The LNC itself recognized this problem. It voided its own resolutions. That is not a technical defect. That is an acknowledgement that the process failed. If the committee chooses that path, the outcome is straightforward. The actions are void for lack of notice. But even if the committee looked beyond notice, the same result follows. The SIC process investigated, found misconduct, declared unfitness, and imposed consequences.
Gave an opinion.
That is discipline.
No, the consequences, you're not entitled to the good opinion of the LNC.
The respondent and the Harlos amicus attempt to rely on ambiguity, but ambiguity cannot eliminate rights. It must be resolved in favor of protecting them. And the examples discussed in the amicus filings confirm the line. LPNH, investigation without discipline. More, opinion without discipline. SIC, discipline without process. Ultimately, the committee does not need to choose between these theories. It can choose clarity. It can choose the simplest and strongest ground. The notice was insufficient. And if the committee wishes to go further, the record supports that as well. Under Article 7, Section 12, if an LNC action if an LNC action contravenes the bylaws, it must be declared null and void.
It didn't contravene the bylaws.
Here, the notice was defective. The process was deficient, and the result is clear. These actions must be declared null and void. Also, I hope this helps too, but let's see. A point of order on the same continuing breach may be raised at different sessions. That is the standard of why appeals on the same or similar facts can be brought.
Somebody
the JC accepted a second appeal on the JFC.
It's not
and
a
at least asking
breach.
for consistency is requested. Thank you.
What's the continuing breach?
Okay, thank you. Mr. McGee, your rebuttal.
He's muted, I think.
Mr. McGee?
Sorry. I would like to note for the record that this is the third time I've had to deal with the misreading of section 1.02.1.
Campbell is
again,
the
this is the third
Colorado
time
Mesa
that
state
the
organizer.
appellant has conveniently discontinued their reading of that section before getting to the very last part. Previous notice is not required unless specified by the party bylaws or its parliamentary authority, though vote thresholds may change based upon whether or not notice was given. And the only provisions in Ronner for previous notice pertains to bylaws amendments and amendments to special rules of order. These resolutions were neither. Therefore, previous notice does not apply.
Correct.
As for the argument that
an original motion.
the LNC conceded that their motions were out of order, if you read the response to Mr. Bowler, Mr. Nikela makes it very clear that the reason why he's ruling the previous resolutions out of order is for procedural clarity, not because he's conceding that the content was inappropriate. Furthermore, actually, that really is the primary basis of my response. The notice issue is non-existent. As stated in my opening statement, this is all contingent on the disciplinary standard of disciplinary in substance, which fundamentally misunderstands the difference between disciplinary censure and motions of censure.
And the fact that the LNC
is not
cannot
accepted,
do
all of
discipline
the
against a member.
questions of notice are irrelevant because no disciplinary notice is required. Thank you.
Okay, thank you. Do any of the JC members wish to ask further questions? Mr. Krawchuk?
Please, no.
I am clear, sir. Thank you for everything.
Thank you, Ken.
Mr. Seebeck?
Yes, I have one last question. This is for both Mr. McGee and Mr. Campbell. Is the LNC expressing an opinion by resolution a disciplinary procedure?
No.
I'm sorry, what was the question?
Is the LNC expressing an opinion by a resolution a disciplinary procedure or action?
Only if it's limited to opinion.
That's what a censure
That's all I
is.
have.
FBI, I'm sorry to report that the
Okay, I have no further questions. I assume Mr. Montani is not still not here. Mr. Kinsella?
Yeah, this is a Jesus moment. Okay, bye-bye.
Mr. Kinsella still here? Mr. Kinsella, are you muted? I'll come back to Mr. Kinsella. Mr. Stratton, I believe, is still not here. Mr. Latham, do you have any questions on this round?
Yeah, let me ask this, and I'll just say that as an attorney, I think the res judicata concept is interesting. I just unfortunately think our bylaws and rules currently do not allow it. It would be interesting maybe to construct a rule. Maybe we need to raise the petition threshold for these kinds of things. I think of someone who's a party member who may want to bring up an issue to the Judicial Committee, and they have to confront this kind of very confusing legal doctrine that could be arbitrarily kind of invoked.
Well, Rob, maybe I should bring the
committee,
the joint
maybe not all the members are law trained, say, it kind of smells like what we did earlier. So we're not going to this time. So I think it's interesting to ponder, but it actually does get me to another legal concept, but hopefully it's I'll express it or put it out there in a way that is understandable to the layperson. So Mr. Campbell, are you familiar as an attorney with the concept of harmless error?
I would need more context on contractually, judicially.
And maybe you're muted.
Oh, can you hear me now?
Okay. And I don't mean to play gotcha like I think some of these questions have been. Yeah, I heard you, and I heard you say no. On on harmless error.
There was quite a bit
kind of the
before
concept
2024,
is,
but this is way more.
even if everything you say is true, so what? And the reason I kind of put that out there is I'm looking at Mr. Jacobs' brief, and in some ways he raised a lot of the same issues that your petition raises, but then there was this agreement, and he drew a petition, and then the LNC did some different things. They, I guess, changed the text of their resolutions, but there was language, I think, in Mr. Jacobs' petition that was supported by some others, just talking about, gosh, had there been sufficient notice, more people could have lobbied the LNC, and maybe there would have been a different result. So, but that's missing from your petition. So when you're talking so much about notice, I guess I'm trying to figure out, how was the petitioners, the signatories to your petition, how was anyone prejudiced by, I think what everybody admits was there in the LNC to consider it, and then passing the resolutions they pass. Is my question kind of clear there? So
it's really
I think of the concept as harmless error, but a layperson might, so what?
I mean, so harmless error, there's different factions of belief of application of harmless error. I mean, if you're talking contractual versus judicial, this being the Judicial Committee, if we're gonna go to where are we land, a harmless error would actually be a great reason to overturn a decision. So, like, if
unpack that. If it's harmless, why would we?
Or not harmless. If there's
a decision that's harmless,
if there's a wrong application of law, it would be retried. And if it's off of like the judicial, like they would be allowed to remand it. If there was something that's important to fix for like the case law. Does that make sense? It's like they might remand something really quick.
Well, it does, but I don't think you're grokking the concept of harmless. If nothing changes, if nobody was harmed by the say inappropriate notice problem.
Define harm, though. I mean,
then why do this again?
Define harmed, though. She was named in
say it,
right? Wasn't that part of the?
But she
testimony given is that she was mentioned on the website.
But let's assume that Ms. McCardle knew that.
Sorry, Mr. Latham, I think you're cutting out for at least me.
I think the point is,
sorry, man.
Your petition tries to. Oh, maybe it's me. Is anyone else? Am I cutting out for anybody else?
Yes, you're cutting out for me too.
Yes, you seem to be
thumbs down. Who's cutting out? Is it me or is it?
It seems to be you.
Bummer. Well,
cutting.
Okay. Boy, I'm wired in and everything, so I apologize. Is this any better?
It sounds better so far.
Testing, testing. 1, 2, 3.
Can you hear me? Am I okay?
All right.
I hear everything you're saying now.
I can hear you great. Thank you. Okay, sorry, and I am getting that notice off and on that says the connection's unstable. So I think where again the harm, what prevented Ms. McCardle or others in support of her cause advance of their August action?
Well, I guess if they knew better what they were actually going to be doing, if they're just considering the investigatory report, okay, you guys can talk about this. But if they're giving notice that they're going to adopt the special can't talk. We're 2 hours in this investigatory committee report, that's a different conversation. I could see wanting to skip out on, we're going to talk about it to we're going to adopt it. Those are two different things.
But they didn't have to
Well, what about
it.
the resolutions? I mean, the resolutions were out there in June, and there were just slightly different resolutions in August. So, I mean, again, how was one side prejudiced?
The threshold matter here is when we get,
because I think in Mr. Jacobs.
Oh, go ahead. Sorry.
No, I think that's what the question in harmless error is kind of, does an error substantially influence the fairness of a proceeding? And so I just, come back to the question of how, maybe that was the case when Mr. Jacobs filed his petition.
Oh, Rob, you're just breaking up bad.
The problem was addressed by the LNC, and so a month and a half goes by, and then the LNC has issued notice of concern.
I'm sorry. Are you asking? I'm sorry. What are you asking?
Yeah. So why you're saying if notice is bad, then everything that comes after it is bad.
Right.
But again, the concept in harmless error is, okay, so what? It's not now just a 2-day gap; it's a month and a half gap. And I mean, are you claiming that people were surprised as to what happened in August?
I don't want to talk about what people be surprised in hearing about. I just think that if the notice were different, maybe there would be an actual quote unquote trial where the parties
but they
could be present to
You're
hear from the
asking them to do
witnesses
something
and
that the
examine
bylaws
and cross-examine.
prohibit.
If we're talking trials, I
Jesse,
know this is
if there
much
was
more
a trial, you would be here
informal.
appealing that
Okay,
there was
well,
a trial
but you're
that they
assuming
weren't
it's problematic
allowed
if there
to
was a
have.
trial.
You are setting up a Kafka
Of course, there
trap,
was not a
and I
trial,
see
and
through your
I think the LNC's
bullshit.
position is that this kind of censure is not deserving of a trial. So
No,
just,
it doesn't require
regular
one.
non-disciplinary censure. What's the harm in the month and a half notice?
So my perspective here is that the LNC didn't commit a harmless error. There was harm to members, that being plural. And the LNC makeup changed between February, June, and August. But what that doesn't mean that they
This
can
isn't
continue
in good
business
faith. I'm sorry,
based
it's
on
not in
actions that
good
were
faith.
improperly noticed or were improperly disciplinary matters.
Oh, I keep forgetting to clean the cobwebs. This is how bored I'm getting.
Okay,
I'm looking
still,
at the cobwebs
maybe
in my
I'll come back
studio.
to you. I think I want to hear from Mr. McGee.
Oh my God, they're bad.
On this question. Is it proper for this judicial committee to kind of consider the so what question on notice? What was any kind of notice problem that might have existed
I don't think you'll be able to see it with the lights.
Have been fixed in August, and why is that?
No, you can't really see it with my studio lights, but they're bad.
When you say, so what, could you explain to me the reasoning again? Because I wasn't quite following earlier because your audio was a little bit choppy.
Oh my God, I'm trying to get you guys to see how bad the cobwebs are, but
in the law
I've got
harmless
pretty
error,
bright
but I think a layperson
lights.
is so what? And so I think the petitioner
I didn't
here
put
is
this
just
studio light on though, and my lighting's still pretty good.
There
Let's
was
see
a
if it
notice
changes when I
problem
put this
in
one on.
June, and so that taints everything that follows.
Yeah, that's even better
it's
lighting.
Continuing breach, they might say. But practically speaking, the harmless error analysis is okay, even if that was
but that
an
light
error,
is too bright.
Did that
from this
affect
angle.
the
Look
fairness
it's
of the proceeding?
It's
and so
my
that's
hair.
kind of what I'm getting at is what was the harm, even if there was some kind of error in notice that happened in June? Is that error cured in some way by things that happen, later, the notice of the meeting for August and then the August meeting?
I think
I'm going to go
with
to
respect
just
to the resolutions, I
cement
think the
wall
August
again
24th meeting
soon.
was sufficient to cure any potential issues. Again, while the LNC did not concede that there were substantial
Where'd
issues.
Lucy go?
If there were, I would argue certainly that the meeting of August 24th, where the new resolutions were adopted, certainly cured any potential defects in the original resolutions.
And just, I get that's your argument. I guess I want to have a little support for that. Is there something in our, bylaws or parliamentary authority that helps us answer that question? And maybe if it's just, I'll get that if this is kind of a new hitting you cold for the first time.
This is
that may be a
another
research project.
This is the Lucy cam.
But, if you know,
she's not
I
here
think
right
that would be
now,
helpful
but
for us
that's the Lucy cam.
mull.
I guess in order to answer that question, I would need to better. I'm not quite sure I understand what you're asking.
Me either.
Because
I have no idea what he's asking.
Sounds like, okay, even if there was an issue with notice, if no one was hurt, so what? It sounds like that is
exactly.
No harm, no
okay.
foul is
no,
what
I think that's
saying.
a good way of framing it. Because this August 24th meeting, I mean, I'm sure I could probably find it in the materials, but you know off the top of your head how much of a time gap took place between, was there a meeting August 24th and there was probably a call of the meeting before that?
Yes.
The call of the meeting was on August 10th. It's in my respondent brief.
So man, 2 weeks. And of course that follows a prior meeting in June.
Yes.
So that's my, is it okay for this judicial committee to say, even if things were problematic in June,
but
people had plenty of notice of what was coming down the pike for the August 24th meeting because of the August 10th.
I just looked at it August 18th. My bad.
Okay. Well, so 6 days.
Yeah, and the policy manual requires 5.
But same question. So is there a so what argument to be made here? And
Rob,
if so,
what's
really,
this is
authority support or against
the
that?
JC, I think, really
maybe I'm confusing
questions too far.
There's a problem in bringing legal concepts into kind of a parliamentary bylaws kind of question. Maybe they're not applicable.
They are applicable when it comes, because
I think that's exactly
as law qua law.
I think that's exactly
but
where,
as
at least currently, where you're hitting the nail on the head here.
Of just
There are
how
a number
you
of legal
resolve
concepts
disputes.
that, while valid in a court of law, don't necessarily pertain to the bylaws, the LNC special rules of order or parliamentary procedure as outlined in Roberts. And I know that's a disconnect that a lot of people have had to struggle with, myself included. But I think there is a fair argument as to whether or not there should be provisions somewhere either in the bylaws or in special rules where some of those concepts are introduced in order to prevent confusion like this in the future. I would say at this point in time,
you don't have
it's probably going to be a
Jonathan.
matter for a future LNC. But what I will say is that,
or the convention.
I understand where you're coming from, and I think
I'm
there's
glad
definitely
you do,
potential
because
for
I don't.
addressing that in the future.
Okay. Thank you for indulging me, Mr. McGee, and Mr. Campbell. I'll just come back to you now that maybe you've had a chance to chew on this question. Are you able to kind of give me any support one way or the other on how the folks, you and the folks in support of your petition,
they're harmed because they don't
can
like
show
it.
that there was a harm.
Their harm is that
in
they
notice
don't like
that you're challenging in June for things that ended up happening in August, late August.
Right. I think as a baseline, we are correct to, recenter here that this is not a court of laws. Questions were asked with that framing in mind, but really this is the Judicial Committee for the Libertarian Party. And we're looking at what the bylaws say. I would say, as an aside, we're really worried about harm still, because there is potentially some harm that could be defined within the bylaws. And the SIC report also targeted other members too. But I think procedurally, motions to ratify is how the Roberts rule. That's a Roberts rules mechanism to fix.
There was no
notice
motion
issues.
to ratify.
The LNC, if I'm not mistaken, didn't ratify the motion to adopt the SIC report. This was an issue in June, and the LNC didn't try to fix it if it was
But
fixable.
it wasn't an issue because it
I hope
wasn't
does that answer your
an
question?
original main motion.
I'm going to chew on it as well. So thanks for your reply, Mr. Campbell and Mr. Chairman. I think that concludes my questioning. Thanks.
Okay, Mr. Latham.
I got such a severe widow's peak, and my part's not exactly.
Well, we still have Mr. Kinsella if he's available. Mr. Kinsella, are you there?
Bald spot.
Yeah, I'm here.
It's been there forever.
I don't have anything further.
Everyone's like, oh, because she dyes her hair. No, it's looking pictures.
Okay, well,
from
I
6
guess
years ago.
that concludes the hearing.
I want to try to get my part down the middle.
Thank you, everybody.
It concludes.
Recording stopped.
Okay, see how when I do it really down the middle, it's a widow's peak. Okay, that's it. After we discussed hair and everything else, let me get this Zoom meeting off the screen here. How do I? Yeah, just here's the. Oh, don't want that. Let me hold on 1 second. I need to. Is it still showing? Hold on. I need to stop sharing my screen. No. You guys give me 1 second here. Because I don't know how to get that off my screen. I need to find my scenes and go to a new scene. Here we go. I don't know why it was doing that. All right, I'm going to stick around for a few minutes to see if you guys have any questions. I have short attention, so that's why even like when I was a secretary at the LNC meeting, I'd be like, yeah, I got to go look at something else in order to like refocus, because sitting still for this long. I've got, yeah, in any event. Oh, I want to put up Jake's comment here if anyone else has any other comments. Also, I'm going to do the YouTuber stuff I couldn't do in the beginning. Actually, I can't because the scene doesn't have it, but subscribe if you'd like. I am going back to doing more. You might have seen the content I did on the evangelical dark web on Friday, which people seem to enjoy. Of course, I'll do the LP stuff, but I have a bunch of commentary videos loaded up. And I know people thought it was kind of dull before when I was covering the Wolf v. Melania Trump case, but now all of a sudden with her like trying to get ahead of something, it's become even more relevant. And remember, later this month, there is the hearing on the motion to dismiss of Macron versus Owens. So I'll be getting back to some of my other content, and I guess that will be it for this evening. Oh yeah, the YouTuber stuff. Please subscribe. I'd really appreciate it. And if you enjoy this type of content, it is very niche. I would appreciate it if you become a patron at patreon.com/Pink Flame of Liberty. Or of course, like the one-time stuff helps. Because YouTube keeps your... I know everyone's always like, she has a monetized YouTube channel. One day I'm going to get on here and show you guys the monetization screen. I think I make like $2 a month from ads because it's just not that kind of channel. And YouTube holds any earnings until you reach a certain threshold. So I get that from super chats and super thanks. So if you'd like me to get my YouTube earnings, you can add to me getting my threshold by hitting a super chat or a super thanks. I'd super appreciate it. It's a lot of supers, isn't it? But we are going to go for this evening. As you know, I had a terrible cold last week. I'm losing my voice again. And yeah, that's enough. Good night. Mi guapas de libertad.
what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians, or choose to be an accountant because it's safe in the business, not because they want to